welcome. We finished last time with the statement that the Coronation Oath was fatally corrupted at the time of the passing of the 1688 Bill of Rights. We'll now examine how that happened and the implications of this crime. For much of this information we are indebted to the diligent research of David Robinson and his mentor Elizabeth Becket. In the early days of the Kingdom of England established by Alfred the Great, the Coronation Oath was based on traditional texts, but was first written down for the coronation of Henry I on the 5th of August 1100. It is rather basic and was stated thus: "Know that by the mercy of God and by the common counsel of the barons of England I have been crowned king of this realm, and because the kingdom has been oppressed by unjust extractions, being moved by reverence towards God and by the love I bear you all, I make free the Church of God. I abolish all the evil customs by which the Kingdom of England has been unjustly oppressed." The statement about making free the Church of God is most obviously interpreted as underpinning the oath by the Ten Commandments, the law of God, and therefore the principles of common law. The common law constitution, including this original coronation oath, is all grounded under the Christian principles even today. This oath was originally an agreement created between the people by way of the feudal barons and the king under the Christian faith, and is therefore a part of the permanent constitution, as is Magna Carta 1215. As stated before, both predate Parliament, which therefore has no lawful authority to reaffirm the Coronation Oath in statute form as an Act of Parliament in 1688, or indeed the Magna Carta in 1297. Acts or statutes cannot become permanent unless accepted to become laws by royal assent, and then only if they comply with the people's constitution under the constraints of the original Coronation Oath. Let's recall, I make free the Church of God. That is, according to God's law, the Ten Commandments or the common law. Royal assent must be provided solely by the monarch. Under the Constitution, Parliament, which only later appeared on the scene, has no bearing or input into the matter. Parliament's job is to write legislation. The monarch's role is to judge whether such accords with the Constitution or not, and the people have the final say by having the right to annul unjust laws by annulment by jury. This is, as clear as can be, the ultimate safeguard for the people against unjust oppression by either the monarch or the Parliament. The process thus ensures that all laws are therefore by consent of the governed. Let's now look at the Coronation Oath Act of 1688 to see how it causes the oath to differ from the original. The Archbishop or Bishop shall say, "Will you solemnly promise and swear to govern the people of this Kingdom of England and the dominions thereto belonging, according to the statutes in Parliament agreed on and the laws and customs of the same?" The King and Queen, in this case William and Mary, shall say, "I solemnly promise so to do." Archbishop or Bishop, will you to your power cause law and justice in mercy to be executed in all your judgments? King and Queen, I will. Archbishop or Bishop, will you to the utmost of your power maintain the laws of God, the true profession of the gospel and the Protestant Reformed religion established by law, and will you preserve unto the bishops and clergy of this realm and to the churches committed to their charge all such rights and privileges as by law do and or shall appertain to them or any of them? King and Queen, all this I promise to do. The monarch then kisses the Bible. There then follows, as part of the Coronation Act 1688, the following statement: "And be it further enacted that the said oath shall be in like manner administered to every king or queen who shall succeed to the imperial crown of this realm at their respective coronations by one of the archbishops or bishops of this realm of England, for the time being to be thereunto appointed by such king or queen respectively, and in the presence of all persons that shall be attending, assisting, or otherwise present at such their respective coronations, any law, statute, or usage to the contrary notwithstanding." That statement is an obvious attempt to bind all future parliaments to an unalterable piece of legislation, itself a treasonous act, since only the Constitution is inviolable law. We notice immediately the difference between a simple oath, which promises to uphold the laws of God, and thus the common laws, from one which renders the monarch subservient to the Parliament, treasonously usurping the monarch's constitutional authority. Another difference is the special privilege and status granted to the clergy, which we recall form a major part of the infamous Estates of England. This would be a completely unnecessary addition to the oath if the government were to indeed rule with equity and justice, treating all people as equal under the law. Just these two provisions of the 1688 Coronation Act themselves embody extreme danger to the rights and protections from affront which the Constitution, as laid down in the Magna Carta, provide for the people. Since William declined to sign or assent to the Declaration of the Bill of Rights and instead requested that Parliament grant him accession by an Act, it is perfectly obvious that the 1688-89 Bill of Rights and the 1688 Coronation Oath Act are nothing more than unprocessed pieces of government legislation which have treasonously asserted parliamentary sovereignty and attempted to bind successive parliaments and monarchs ever since. So finally, let's turn to the coronation oath taken by Queen Elizabeth II in 1953. Notice the changes again. Archbishop: will you solemnly promise and swear to govern the peoples of the United Kingdom of Great Britain and Northern Ireland, Canada, Australia, New Zealand, the Union of South Africa, Pakistan and Ceylon, and of your possessions and other territories to any of them belonging or pertaining, according to their respective laws and customs? Queen: I solemnly promise so to do. The two remaining questions are essentially the same as those laid down under the 1688 Coronation Act. David Robinson sums up this situation admirably succinctly. Quote, whereas the King's oath and constitutional duties had been treasonously usurped by Parliament within the 1688-89 Bill of Rights and the 1688 Coronation Act, the 1953 coronation was but a charade and designed deceptively to appear to govern the peoples, etc., according to their laws and customs. The law established in England, as stated in the 1953 oath, primarily refers to the unrepealable 1215 Magna Carta and original constitutional oath of Henry I. The 1953 oath also involves all Commonwealth nations which still had the usurped Queen as the head. The United Kingdom referred to is of course a corporation. The 1953 oath is intentionally deceptive in its wording. The office of sovereign is vacant as the Queen had inherited a usurped office/throne. She was thus never a constitutional monarch, unquote. And it should be added, neither have been any of those occupying the throne since 1688. The so-called King Charles III is in the same invidious position, possibly even worse, since he has long been actively advocating a surrender of British sovereignty to foreign corporate powers, and should never have been considered even a remotely possible candidate for the office of monarch. Repeatedly, the parliamentarians have since 1688 remonstrated with the monarch that the royal assent is basically a formality and in practice is never withheld. However, the events of February and March 2001 give the lie to this assertion and validate the constitutional power of the Magna Carta in perpetuity. It is as binding today as it was on June 15th, 1215. Unfortunately for Australians, this turgid tide of treason emanating from the 1688 Bill of Rights and Coronation Act entirely swamped the legitimacy of the Commonwealth of Australia Constitution Act, which for reasons stated previously was null and void from its stillbirth in 1901, tautologically trashed by the Whitlam and Hawke governments in the 1970s and 80s, and irredeemably annulled since the invocation of Article 61 in March 2001. If we are to build bulwarks against this burgeoning barrage of betrayal, it is essential for every person of integrity to lawfully stand up and loudly resist these brazen attempts to impose slavery by deception. Next time, we will discuss some further steps we can take to peacefully strengthen our arms in this sacred endeavour. Thank you for watching.